Good afternoon, everyone. And it is this afternoon. It's usually a morning coffee break, but today we're meeting in the afternoon. It's a lovely sunny afternoon, and welcome. We thought today we'd probably have two areas of discussion. One in terms of the economy and how it's going to affect the legal profession over the next 3 to 6 months, or our views on what's going to happen there. And also the second topic on law firm disputes, which, Mark, I know you've got a number of significant ones on. So perhaps we kick off straight away and go into law firm disputes and the messy ones you're seeing at the moment and the experiences you're having, Mark.
Yeah, I think, as you know, I talk a lot about structure. I'm really interested in structure. And over the years, we've discussed a lot. I've presented and written on the subject of LLP versus limited company in law firm structure. And, you know, the pros and cons to both. You know, I like the LLP. It's a flexible thing. We've been dealing with two similar but slightly different law firm disputes over the summer. And they're both in the limited company set up, and they have been a nightmare because obviously if you've got an LLP and you've got an LLP agreement, first of all you can just have a no fault expulsion clause. You know, Howard, we call them the Red Sox clause. So if somebody
yes.
is just being difficult, as long as you follow the process and you don't discriminate against any protected characteristics, you can fairly straightforwardly get rid of them. And also if there's, you know, you have fault expulsion clauses. Both of the ones we're dealing with would have fallen within a fault expulsion clause, really, based on some of the behaviours going on. And as an aside, it's normally behaviours that causes the dispute. But because they're in the limited company scenario, you have them as shareholders, as directors, and you have shareholders agreements in place. And suddenly you get that really messy interface between employment rights, shareholders' rights, and directors' duties. Under an LLP agreement, we exclude section 994 of the Companies Act, which is unfair prejudice, minority shareholders, just as you know, it's standard in LLP agreement, you exclude it. You cannot exclude that in the shareholders agreement. The Companies Act says that you can't. It has to be there. So the minute there's a dispute, somebody's there going, well, hey, you know, I'm bringing a minority shareholder petition. One of them, yeah, it was a 3 or 4 partner firm, and you know, they brought in a £2 million section 994 petition linked to an employment claim and everything else. And I'm just thinking, you know, we got them solved and we got reasonable settlements for our clients, I'm pleased to say, but the amount of work and the fees involved because they're in the limited company were really messy, and one isn't finished yet. We've settled the shareholder dispute, we've got rid of the 994, we've reached a settlement to buy back the dissenting shareholders' shares, but there's still an employment claim rumbling on in the background. So
Mark, you've been presumably acting for the firm, have you, rather than the exiting partners?
We've been acting for the firm, yeah, rather than the partners. So
what did you do over valuation issues? Because that, to my mind, is nearly always the fundamental issue that causes the problem. What's the firm worth? How did you address those issues?
They both had shareholders agreements that had valuation mechanisms in
full mechanisms, not just leave it to the accountants.
Well, somewhere between the thing, but it gets very interesting with a shareholders dispute because you have to do you take into account, you know, post balance sheet items? So on the one where the guy put in a £2 million claim and a massive employment claim, we said, well, of course, whatever the company's worth, because you've got this claim that you tell us you're 100% going to win, we're therefore going to knock 2 million off the valuation, which they didn't like. So
oh, lovely.
You know, I mean, at the end of the day, I often think these things boil down to a bit of horse trading. Yeah,
they always do, don't they?
You have a good evaluation mechanism, you've got that, but because you say, well, okay, yeah, what's the value for your shares? Is there a value? Is there a value to your minority shareholder petition? But the court would just order that the continuing shareholders buy out your shares, but at what value? Is there a value to the employment claim? Yeah, and is there a value to the damage you have done to the firm because of your breach of directors' duties? So, and it then boils down, as always, with a messy partnership shareholder dispute, who's got the deeper pockets and the greater willingness to fight.
Mark, in these situations, I often bandy around, in family businesses in particular, the argument that a company is a quasi-partnership, not really knowing what a quasi-partnership is. Can you, and when it applies, can you enlighten us when a quasi-partnership exists and hence minority interests or valuation for a minority interest doesn't apply?
It depends whether there's a discount for the minority interest, then it doesn't apply. It tends to be in, I can't remember the exact number off the top of my head, but it's small numbers and where the thing is run like a partnership. So where you're looking at sort of a standard smallish law firm with half a dozen partners, it's going to be a quasi-partnership. So yes, you won't be getting the discount for the minority shareholding in that case.
Good, you haven't disagreed with what advice I've given in the past, so that's fine.
so really it was just a case, we've had a couple of these on, and we've done a couple of fairly standard LLP disputes over the year as well, and they are just so much easier. They're never very easy. This whole concept of being a shareholder and an employee and a director, people think, oh, yippee, it's great, we're going to make some tax savings when on incorporation. But in terms of running, it's more complicated, and certainly if you have a dispute, it's way more complicated and way more expensive. So it's interesting as to whether the tax savings over the years have been eaten up by the additional legal fees for sorting out the dispute.
Interesting you say that, Mark. I've looked at some of those calculations, and going back 10-15 years ago, there were significant tax savings when you actually got tax relief on the write-off of goodwill. That all disappeared, and as you say, with the complexity, it's really very marginal. It's at the most perhaps 4 or 5% of your total profits, but then you've got all the costs associated with it and the hassle. And as corporation tax goes up in 3 years' time, I haven't fully run the numbers yet, but it does look pretty much as though there's going to be no advantage for converting to a limited company. Keep it as an LLP, far more flexible.
I was going to say there was a time, Howard. I mean, you're the tax expert, but there's a time when it was almost considered to be a no-brainer.
Yeah.
That the default position was you might as well convert to a limited company because of the tax savings.
Yes.
Are we now saying that it's now balanced on a tax front, and Mark's arguments are starting to push it the other way?
Absolutely. Absolutely. And as it goes to 25% corporation tax rate, yes, absolutely. I suppose the only question mark is if you're a highly geared firm needing to pay down debt, then to pay down debt out of profits taxed at still only 25%, as opposed to debt taxed at 45% is still better.
I think that there are still scenarios where it makes sense. I think the classic personal injury firm, as was, where you had a very small number of owners and a very scalable business, that made sense. And if you're looking for outside investment, if you're looking to float, if you're looking to go down the EOT route, Howard, which I know is one of your favorite topics, then the limited company makes sense. But if you're just sat there currently with 3, 4, 5, 6 partners thinking we really ought to incorporate, and to be fair, you should have had that thought 10 years ago, but nonetheless, if you're still there, please do it. But unless you're planning investment or massive borrowing or anything weird like that, just think of the LLP.
Well, that brings us to the end of this first session recorded in early August of this particular coffee break. Watch out for our next session, recorded at the same time in early August, on the subject of the economic outlook for law firms, coming to a laptop near you shortly.